We will discuss about the competency of the cost of arbitration. And group six, we will talk about I will to present about question one, the subject to settle the complaints about the jurisdiction of arbitral tribunal. And I'll present, we have two parts. The first is jurisdiction to appeal against the arbitral tribunal decision on the invalidity of the arbitration agreement, the enforceable arbitration agreement, and the jurisdiction of the arbitral tribunal. The second part is the complaint resolution procedure about the complaint against the arbitral tribunal decision on invalidity of the arbitration agreement, the enforceable arbitration agreement, and the jurisdiction of the arbitration council. So we move to the first one. Um, for request for settlement of the complaint against an arbitral tribunal's decision on on an invalid arbitration agreement or an enforceable arbitration agreement or the jurisdiction of the arbitration council. The subject that the subject that have a jurisdiction is the court where the arbitral tribunal makes the decision unless the party have agreed to choose another specified court. Whereas for the case during the dispute settlement process, if the arbitral tribunal is found to be beyond its competency, the party may lose complaint with the arbitration council. The arbitration council is responsible for considering and deciding. Uh, the settlement of the complaint against the arbitral tribunal decision on invalidity of the arbitration agreement, the enforceable arbitration agreement, and the jurisdiction of arbitration council. Um, the party complained the arbitral tribunal decision about the absence of the arbitration agreement, the invalidity of the arbitration agreement, the unenforceable arbitration agreement, the jurisdiction of the arbitration council to file a complaint. The complaint must have the content which are regulated in Clause 2, Article 44 of the 2010 Commercial Arbitration Law and be included with the document and evidence specified in Clause 3, Article 44 of the 2010 Law on Commercial Arbitration. If the arbitral tribunal doesn't have an issue, the separate the decision on the jurisdiction of the arbitral tribunal, the requester must provide the document and the evidence to provide that the arbitral tribunal doesn't have authority to settle such dispute. And within 5 working days from the day of the receipt of the complaint and the document and the evidence attached to the application, the court must notify the arbitration council that the court is handling and resolving the complaint. And the judge shall be so based on the complaint paper, document, and the evidence attached to the application and the revision of Article 5618 of the 2010 law on commercial arbitration to determine the complaint about the absence of an arbitration agreement. The arbitration agreement is invalid or the arbitration agreement cannot be performed or the jurisdiction of the arbitration council is valid or invalid. In the necessary case, the judge may request arbitral tribunal to present their opinion on the complaint content. And within the time limit specified in Clause 4, Article 44 of the 2010 Commercial Arbitration Law, the judge must consider and issue the decision to solve the complaint. And within 5 working days from the day of the decision on complaint settlement, the court shall send the decision to the party. And to the party, the arbitration council, the arbitrator, and the people procuratory of same level. Pursuant to the provision of law, the judge accept or doesn't accept the appeal against the decision of the arbitral tribunal about the absence of an arbitration agreement. The jurisdiction of arbitral tribunal, the court shall specify the reason and ground for accepting or not accepting the complaint, depending on the specific case as follows. In this case, the court determined that the dispute is not within jurisdiction of the arbitration council. There is no arbitration agreement. The arbitration agreement is invalid or the arbitration agreement cannot be performed. The following handling shall be made. In this case, the arbitration council has issued a decision to suspend the settlement of the case. The party have the right to agree and choose a method of dispute settlement. If the case is being resolved by the arbitration council within 50 days from the day of the receipt of the court complaint settlement decision, the arbitration council must issue the decision to terminate the settlement, settle the dispute according to the provision of Law 6, Article 44 of the 2010 Commercial Arbitration Law. And if the arbitral tribunal has issued an arbitral award, one of all parties may request the court to annul the arbitral award according to the general procedure. And in case the court determine that the arbitration council have a jurisdiction to solve the dispute, there is an arbitration agreement, and the arbitration agreement is not invalid. The arbitration agreement is enforceable, and so it shall be handled as follow. If the arbitration council has issued a decision to determine the settlement of the case within 50 days from the day of receipt of the court's decision, the arbitration council um, shall continue to handle and solve the dispute under general procedure where the arbitration where the arbitration council has issued an arbitral award. One of all parties have the right to request enforcement of the arbitral award, register the arbitral award, or request the court to annul the arbitral award according to general procedure. And last, in case the dispute is being resolved by the arbitration council, the arbitration council shall continue to solve according to solve it according to general procedure. And this is the lesson one of Rupsik. So thank you for your listening. And the next is the lesson two. Yeah.
Bắt đầu Bèo.
Thấy màn hình chưa?
Thấy rồi, thấy rồi, thấy rồi.
Hi everyone, we are group one. Therefore, member in my group, Khánh Vi, Phương Lâm, Thanh Trúc, and me. I will present the question two, jurisdiction of the arbitral tribunal. First, arbitration council's authority. Regarding the jurisdiction of the arbitral tribunal, if the jurisdiction of the court as provided for by national law and is empowered by the state to accept and adjudicate the jurisdiction of the arbitral tribunal shall be assigned by the parties to the dispute. The jurisdiction, rights, and obligations of the arbitral tribunal derive from the arbitration agreement. The unanimity of the will of the disputing parties based on the provision of the law governing the arbitration agreement, the applicable law on dispute settlement, and the law of the place of recognition and enforcement of arbitral awards. In international law, the arbitral tribunal has the following powers: to conduct the arbitration unreasonably, decide the applicable law and the venue for dispute resolution, the decision on the language of the arbitrator, collect documents and evidence, request witnesses, confirm the testimony of the witness, examine the matters of the dispute, appointment of experts, apply temporary emergency measures, arrange financial security for arbitration costs. In Vietnam, Arbitration Council authority on acceptance of the case, procedural matters. Firstly, at the stage of accepting the petition, dispute settlement application, the application center receives the plaintiff petition, Article 5(7) of the VAC rules and Article 30 and 31 of the law on commercial center. After that, the center will send a notice of the lawsuit to the defendant so that the defendant can submit a self-defense statement and a counterclaim, if any. The petition, self-defense statement, counterclaim, if any, will be forwarded to the arbitral tribunal after it is established. Article 5 of the law on commercial center stipulates that a request for dispute settlement by arbitration is that the parties must have an arbitration agreement. Article 49 of the law on commercial center stipulates. Before considering the content of the dispute, the arbitral tribunal must consider the validity of the arbitration agreement, whether the arbitration agreement is enforceable. Article 47. Thus, as opposed to court proceedings, the acceptance of claims in arbitration proceedings begin when the arbitral tribunal, not the arbitration center, considers the validity of the arbitration agreement instead of examining the contents of the plaintiff petition. Secondly, the arbitral tribunal authority to decide on procedural matters. During the dispute resolution process, the arbitral tribunal issues procedural orders that supplement the original procedural order on the matters relating to the proceedings. The content of the procedural order includes the basic contents of the language of dispute resolution, the location of the dispute, the law applicable to the dispute settlement, the type for proceeding, provide evidence, expert evidence. The arbitral tribunal has the right to issue a timetable for the proceedings, but the failure to accept additional evidence after the expiration of the time limit is contrary to Article 46 of the law on commercial and goes beyond the provisions of Article 19, Article 25 of the VAC rules on the jurisdiction of the arbitral tribunal to collect evidence and the right to provide evidence of the disputing parties. Regarding the venue for the trial, the arbitral tribunal prescribes a timetable for the parties to provide evidence. At the end, the venue for the meetings, the arbitral tribunal shall have the power to decide the venue for dispute settlement only if the parties cannot agree on the location. Article 22 of the VAC rules. Any provisional emergency measure applied by the arbitral tribunal that is different from the provisional emergency measure provided for under the law on commercial centers and the VS rules is a violation of Vietnamese law. The arbitral tribunal will have to compensate for damage if it causes consequences due to the incorrect application of provisional emergency measures. Article 49 of the law on commercial centers. The court's intervention in the arbitral tribunal. Currently, the law on commercial centers stipulates the court's jurisdiction over arbitration activities in Article 1, 41 to 44, 47 to 49, 53, 68, 70, 71. In essence, the role of the court in the arbitration process is very regularly regulated by the law in both the law on commercial center and the civil procedure code 2015. Next, Henry will present in the United Kingdom.
Continue. The jurisdiction of the Arbitration Council in the United Kingdom. In the United Kingdom, the jurisdiction of Arbitration Council is given by the parties in a dispute by a financial arbitration agreement in which the parties who give the jurisdiction to an arbitration tribunal. Under the Arbitration Act 1996, the arbitration agreement will be referred to by the parties to make future or present arrangements for arbitration. Although the parties are free to choose, not all disputes can be resolved by the Tribunal of Arbitration. In such cases, non-arbitrable disputes often involve mandatory law or public policy. The Arbitration Act also provides that the arbitral tribunal may rule on its own substantive jurisdiction. Therefore, unless the parties agree otherwise, the arbitral tribunal may have the following jurisdiction: whether there is a valid arbitration agreement, is the court properly constituted, and the matter submitted to arbitration, whether is according to the arbitration agreement. Besides, the rights of a party to seek to challenge the jurisdiction of the court is limited under the 1996 Arbitration Act. However, the parties may also apply to the court to dismiss the arbitrators in the following cases. 1. There are circumstances that give rise to legitimate doubts about his or her impartiality. Second, the arbitrator selected is not qualified as required by the arbitration agreement. Third, and also the last, he or she is physically or mentally incapable of proceeding, or he or she has refused or failed the proper way to proceed with the proceeding, or used all reasonable dispatch in proceeding or giving an award. Lastly, I want to bring up some comparison between the regulations the regulations with reference to tribunal's competence. So as we can see that the provisions on the jurisdiction of the arbitral tribunal in Vietnam are quite similar to those of the UK. However, in Vietnam, the arbitration law clearly separates the jurisdiction between the arbitration center and the arbitral tribunal. So the jurisdiction of the arbitration body is also divided. In encapsulation, we can see that the arbitral tribunal is a different kind of judges or juror in the courts. However, the way it functions, it's quite different from the traditional courts proceeding. And as a matter of fact, in Vietnamese law, we regulate the least out of the arbitrations council, since it's different method of dispute, it's a different method of settling disputes. This is the end of our group presentation. And let's move on to the third question.
Hello everyone, today I'm talking about in the arbitral tribunal required to make an independent decision on jurisdiction. For arbitral tribunal competence to settle dispute, Article 43 of law on commercial arbitration 2010 demonstrates the principle of jurisdiction, allowing the arbitral tribunal to exercise its jurisdiction even with respect to review decision of validity of the arbitration arrangement. The purpose of this principle to ensure that disputes are reviewed and resolved accordingly. The arbitral tribunal jurisdiction remains the same even though the contract evolves. In the event that the arbitral tribunal consider that the contract in which the arbitral agreement with content is non-existent or invalid, the arbitration arrangement shown to exist and be valid. Therefore, the arbitral tribunal still has the authority to decide on the dispute application of the party and to settle their claim, even though the contract might not exist or be false.
Competence of the Board of Arbitration. Question. Infinite term review the decision for determining the competent authority of the arbitration council. Contain competition and validity of the arbitration council statutory jurisdiction. Analyze the competence of the arbitral tribunal statutory jurisdiction, the jurisdiction and sort of invalidity. According to arbitral model law on international commercial arbitration, have the interpretation of jurisdiction of arbitral tribunal in Article 16, Chapter 4 provide as follows. Article 16, Clause 1, principles of competence. principle of the separability or autonomy of the arbitration clause. Clause 2, the provision detailed in paragraph 2 require that any objection to the jurisdiction of the arbitrator be raised as soon as possible. Clause 3, where the arbitral tribunal stipulates a preliminary question that it has jurisdiction. Article 16.3 give the court immediate control to avoid wasting time and money. In one, analyze the competence of the arbitral tribunal statutory jurisdiction. In consensus arbitration, the authority or in or jurisdiction of the arbitrator derived from agreement of the parties. They knows or solve from which the arbitral tribunal jurisdiction may be exercised. The issue may arise regarding arbitration jurisdiction if they are challenged to this jurisdiction in who or in fact the totality of challenge to arbitration is only likely to arise in practice when arbitration is derived from an arbitration clause. Arbitrator whose jurisdiction derived from a submission agree is unlikely to face a full-blown challenge to his or her jurisdiction. This kind of challenge to the jurisdiction of the arbitrator raises the question of who can decide the challenge. In other words, whether an arbitrator or a court should decide whether to challenge and whether an award under arbitration can be reviewed by the court, and if so, when. In addition, it often happens that the defending or challenging the jurisdiction of the arbitral tribunal is merely a ploy intent to delay and impede the arbitration proceeding by establishing to separability and capacity competence doctrines. The main event of arbitration can be achieved through the jurisdiction and sort of invalidity. The concept of jurisdiction and separability of the arbitration clause arose to rationalize the legitimate desire of arbitrator courts and academy to avert the consequence of arbitration abuse, unacceptable use and behavior. They are to access to competence. First, it means that a court which may simply be an arbitrator is a job having its on jurisdiction and therefore has the power to rule in its own jurisdiction. Second, arbitration agreement operate outside of the original jurisdiction of the ordinary course. The doctrines of separability hold that the arbitration clause and the main contract are treated as two separate agreements. However, the arbitration agreement is the bad. Its validity is suspended at its so this reason. The arbitration obligation arising under the agreement is invalid, terminate or unsuch arbitration agreement will not be able to sue about its validity. The origin of the nullity of the contract is the decisive factor in the correct application of the doctrine of indissolubility. It is important to distinguish between duly entered into agreements, the continued validity of the agreement concern agreements that violate public policy or are characterized by conflict and interest, referred competition or manform agreements whenever signed.
Okay, we come to back to the competence and sources validity of arbitration counsel according to law commercial arbitration 2010. Article 14 formation of an arbitration counsel at an arbitration center within 30 days after receiving a petition and request for selecting an arbitrator sent by the arbitration center. The defendant shall select an arbitrator and notify to arbitration center of request the arbitration center chairman to designate an arbitrator. Otherwise, within 7 days after the expiration of the time limits specified in the clause, the arbitration center chairman shall designate an arbitrator for the defendant. For dispute involving many defendants, within 30 days after receiving a petition sent by the arbitration center, the defendant shall agree to select an arbitrator or to request designation of an arbitrator. If the defendant cannot select an arbitrator within 7 days after the expiration of the time limits specified in this clause, the arbitration center chairman shall designate an arbitrator for the defendants. Within 15 days after being selected by the body or designated by the arbitration center chairman, the arbitrator shall elect another arbitrator as the chairman of the arbitration council, but this time limit. If this election cannot take place Within 7 years, the Arbitration Center chairman designates the chairman of the Arbitration Council when the party agree that there is still from the chapter file for arbitrator testified to the rest of arbitrator within 30 days after the defendant receive the reason. The Arbitration Center chairman shall at the request of one body of the body and within 15 days after receiving such grant, designate for arbitrator. Article 42 and Article 41 include the formation of ad hoc arbitration council and Article 42 train up arbitrator from 3, 4, 5, 6, 7 to see the sources of the validity of arbitration council and Article 43 is according to law on commercial arbitration. Thank you for watching our presentation. We done for the question 4. Nhóm tôi cái phần câu 4 xong rồi.
Hello everyone. After this our group question, our group representation is about the comparative, the timing of complaints between the court and the arbitrator, arbitration tribunal. Our group is the group 5, and there's the member Hồng Đỉnh, Mạnh Khoa, Khánh Linh, Tường Vi, and me. First, I will talk about the timing of the complaint in the court. So it is clear that in the term of the court, the result complaint divided into two times, and this one is the first time complaint settlement. So according to Article 502 of Civil Procedure Code 2015, within 15 days from the date of receipt of the complaint by the court of procuracy is considered to be necessary. It may not be extended more than 15 days from the day of expiration of the time limit for appeal. And about the second time complaint settlement, according to the clause 1, Article 507 of Civil Procedure Code 2015, within 5 working days from the date the complainant receives the first time complaint settlement decisions, if he or she disagrees with that decision, he or she has the right to lodge a complaint with the person competent to settle the second time the complaint too. Next will be the timing of complaint in arbitration. Different from the timing of complaint in the court, the complaint in the timing of the complaint settled in arbitration has just one time. So the reason is that in order to ensure fairness for the complainant, the Vietnamese law has provided that for the first time complaint but still have been complained, or the first time complaint has expired but not had been resolved, or has been resolved but still disagree with the complaint settlement decision of the competent agency, the complainant can make a second complaint. The different competent to settle complaint about the decision and acts of different complaint subjects will ensure the rights of complainant. So in contrast, for the speed of trial, the arbitral award in final and come into force from the day of its issue. Therefore, the result dispute will not be reviewed by any other level of judicial body, except in the case of cancellation of the arbitral awards as required by law. So we move to the law in the timing of arbitral tribunal. According to Article 44 of Commercial Arbitration Law 2010, within 5 days from the day of receiving the complaint, the Chief Justice of the court had the power to assign a judge to consider and settle the complaint. And according to Article 44 of Commercial Arbitral Law, point E, within 10 working days from the date of assignment, the judge must consider and decide the court decision is final. This is the end of our group representations. Thank you for listening.
Okay, so now my group comment the case law. So my will comment the first part.
Decision number 627 to 2017. The company believes that only signed and form the lease agreement on March 1, 2006 with Vindomio. Therefore, there is no arbitration arrangement with plaintiff VC Haiphong. This will stimulate a process when VC Haiphong mature as the plaintiff fail to present documents and evidence to prove the transfer of lease contract from Vindomio to VC Haiphong. In accordance with the law on jurisdiction civils, doesn't represent the issues of inherent own right and the obligations of the lease. Vindomio must be consistent with the content that Vindomio and Dip commit in Article 19 of the lease contract date March 1, 2006. Therefore, there is no basis to believe that the claimants VC Haiphong is entitled to inherit on rights and obligations of the lease in the lease contract date March 1, 2006, include the arbitration arrears. So the court assessment this company's complaints about dispute numbers 9, 16 Ho Chi Minh between VC Haiphong and the companies which is not under the jurisdictions of the arbitration councils of various arbitration centers. The arbitration councils must be issued a decision to terminate the dispute seamless as precise in Clause 1, Article 44 of the Law on Commercial Arbitration. I will go to the judgment compensations. In the group comments section, we will divide it into 9 parts, and I will present the first 3 parts. So first, regarding each party right to claim, the court doesn't intervene on its own to review the decision of the arbitration tribunal. In fact, according to Clause 1, Article 44 of the Commercial Arbitration Law, the parties have the right to submit an application to the competent court to review the decision of the arbitration councils. The law recognizes the right to request a reviewing the decision on the arbitration tribunal for the parties, but in relative focuses on the case where only one party requested the court to review the decision, the arbitration tribunal. In the above case, the decision of the arbitration tribunal, the arbitration will relate to the choose part, but the request to review the decision of arbitration councils only came from the company on one side. The court applies the complaint that date December 6 to 2016 of the company withdraws. Thus, we understand that the right to request the court to review the arbitration decision on jurisdiction belong to each party, and each party entitled to exercise this right with respect to arbitration tribunal decision. Move to the secondly, jurisdiction of the court. This case was filed in Ho Chi Minh City, and arbitration councils make a decision in Ho Chi Minh City. So the People Court of Ho Chi Minh City considered the decision in Ho Chi Minh City to be considered with clause 1(3) Article 7 of the law on commercial arbitrations. Next to the thirdly, time limit for exercising the right to request. Due to the requirement of the arbitration procedure to be fast, the time limit for exercising the right to claim is very short, especially within 5 working days from date of receipt of the arbitration tribunal decisions. The party had the right to submit an application to the competent court to review the arbitration tribunal decision. Law simply use the word time limit, but it instance this is a kind of status of limitations, like requesting annulment of an arbitration award. So there is issues of the status of limitation requesting an annulment of an arbitration award, such as determining start time and time of the status of limitations, are also applied to the periods being studied. Time here is in working days, so holidays are not counted. In the above case, the arbitration council's decisions were made on November 21, 2016. We have a complaint on December 6, 2016 by the companies. In the above case, the court didn't explain more clearly about the observance of the above 5-day time limit. But we will represent the rest.
Okay, now we move to the application for the recognition. The court did not intervene in the first place on its own to review the decision on the jurisdiction of the arbitral panel. The court only intervened when there's an application after the arbitral panel has made a decision on its jurisdiction. A complaint must contain some following details: date, month, and year making the complaint, and name and address, and requested content. In this case, the enclosed documents are in the foreign language. They must be to translate into the Vietnamese in clause 2 and 3 in Act 44. Next is a notice to the arbitral tribunal. The court did not intervene the first place on its out to review the decision on the jurisdiction of the arbitral panel. The court on in the clause 1 article 44, and the complaint party must be stimulate notify the complaint to the arbitration council. However, this obligation is not accomplished by any sanction, so it does not make sense if the complaint party does not notify. Perhaps the decision no 01/2014 in the within 5 working days from the day of the receipt. The complaint and document and evidence attached to the petition to the court and must notify the arbitral panel on the court's acceptance and settlement on the complaint. Next is the common component of the application review. And it is very important to consider whether the arbitral tribunal has jurisdiction, because like an animal of the arbitral acquire a review of the arbitration is a form of the cost supervisor over the arbitration activity, and for the annulment of the arbitral award, the component to consider to the petitor three-member council, because clause 2 article 71 the chief justice of the court appoint a petition review the panel consisting of the three judges, include one judge as the presiding judge assigned by the chief justice of the court. However, for the review of the arbitration council decision on jurisdiction, the chief justice, the court has power to assign two judges to the consider and settlement complaint. It's about how we are in the framework of reviewing the decision of the arbitral tribunal on jurisdiction before this decision on the side. One judge does the component that consider the application for reconsideration or decision of the arbitral is very different from the component that's considered application for the annulment the arbitration. Why we see a very similar consequence when the court follows the direction of the arbitral tribunal. When the court determine that arbitral tribunal no jurisdiction, the content of dispute will not by the resolved by the arbitral council. So the time limit for the consideration and decision in a clause 4 and article 44 simply with 10 working days from the day of the assessment, the judge shall must consider and decide. So the deadline is so very limited because it's the only 10 working days with the time limit. The judge must consider and decide it. However, the time limit doesn't seem to the observe in practice. For example, in a post case, we have the complaint December 6, and 2016, but it was not until May 24, 2017 that the court made a decision on the arbitral tribunal. In order to the upper time limits to be meaningful in the practice, and higher body need to observe the operation for the cost, but unfortunately, this mechanism is not at the present. And there is no specific procedure. In clause 3, article 71, the commercial arbitration, the LAC laws stimulate that the meeting shall be conducted in the presence of the dispute party, the party lawyer, if any, the procurers of procuracy same level. In this case, we do not see the presence of the procuracy and do not see the decision starting that the party have specifically granted any other than the content of the complaint and the requesting in the party. In other words, the procedures is very fast, and the judge assigned to the handle himself without the mandatory participant with no obligation to listen to anyone. So in this case, only one third review the decision, and then seem to the confusion between the existence of the co-temp stay between the disputing party and existence of the arbitration agreement between the disputing party. The lease contract may not exist between the party at all, and this is the content of the dispute, but an arbitration agreement may still exist as is between the party on the basis of the Article 16 on LCA as well as Article 7 on resolution number 1 2014 NQHDTP. In fact, the arbitral panel gave three independent grounds to affirm that that's where the arbitration agreement between the party and the judge assigned to be just didn't deny the basis, but affirm that no arbitration agree exists sufficient evidence to prove that this is an arbitration agreement. This is a procedure reviewing the decision to the arbitral tribunal as prescribed in the clause 1, Article 44 of the LCA. So the judge should have to consider each of the grounds of the arbitral tribunal, assert that there is an arbitration agreement and respected the basis deny each of these grounds, but the church failed to do so. This shows maybe a danger of this existing regulation in leaving on the church to decide the fate of the arbitral panel without any mandatory participant, no obligation to listen to anyone. And finally, in the clause, according to the clause and Article 444, and in a small case, the decision of the arbitral panel determined that the arbitral had the jurisdiction, but one party complained to the court in the direction and the tribunal didn't have jurisdiction, didn't authority. In this case, the court accept the McDuck company and complain about the dispute no 9/16 between the Big C Hải Phòng and McDuck company within not the within the dispute the settlement jurisdiction in the arbitration council arbitration center VA. For the above case according to the clause 6, Article 44, and the arbitration council shall issue decision to suspend do the settlement of dispute. Article 10 to wrestling no 1 and 2014 notes if the case to being resolved to the arbitral panel within 15 days from the day receiving the of the court decision on the complaint settlement, the arbitral council must be issued the decision in the clause in Article 44 in the LCA. In this case, after determining that the dispute was not within jurisdiction of the arbitral council, the court decided that the arbitration tribunal must issue the decision to suspend the dispute, the settlement, and provided for in the clause 6, Article 44 in the LCA framework of the reviewing the decision of the arbitral tribunal. The court make an order to force to an arbitral tribunal to suspend the settlement of a dispute as out of the authority. So we thank for listening. This is the command case.
Rồi, xin mời question time. Mời em đặt câu hỏi đi em. Mời đặt câu hỏi cho những nhóm trình bày đi. Đức, có đặt câu hỏi gì cho nhóm khác không Đức?
Dạ em không thầy ạ. Dạ.
Vì
Không thầy ạ.
hôm nay không ai đặt câu hỏi hết hả? Không ai đặt câu hỏi gì thì thầy chốt bài nhé. Rồi chốt bài để ôn tập nhé. Rồi, nếu không ai đặt câu hỏi gì nữa thầy sẽ chốt bài. Ở đây thầy sẽ đưa vào một cái bài điểm ôn tập để kết thúc cái phần đầu tiên của chúng ta về cái học phần đối với thầy ha. Và sau đó các em sẽ có 5K đối với cô Hương nữa là xong cái môn này. Alright. Nó có thấy cái màn hình của thầy không Đức ơi? Nào rồi.
Dạ ok thầy.
Thấy thầy.
Thấy không? Ok. Rồi. Okay, so we just finished the presentation of the first section. So first of all, I send a great thank you to your group for presentation. I have been seeing that you work very hard, and I appreciate for your effort. It seems that every group working very hard in order to understand the subject and also to discover the very new issue of the subject. It's very good achievement. So I will send my great thank you to all the group once again. Okay, so now I just review some things so you can have a better understanding about the subject and prepare for the test, and also continue the second section with Dr. Hương. Dr. Hương, and you will be learning in very different methods. I don't know if she will give a lecture or give a presentation. Yeah, so that depends on the lecture, but the program will based on a common program of everything we already discussed about common understanding. So the purpose, the university usually also given some different lecture because they want you to have a different method from different lecturer, because everyone is have a different knowledge approach, so you can have a better understanding, a better mood of working with different people. Yeah. So totally our program we designed this, you can see at the very beginning I already show you. So we study about the nature of civil dispute in the civil dispute resolution. So we understand firstly about the nature of civil dispute, the nature of civil dispute resolution, and then some overview of some what we call alternative dispute resolution. But basically, I think we focus more on arbitration than some other method like negotiation, mediation, because other methods very common, very rare in reality, and we rarely use that method. For example, negotiation, mediation, we don't use that very much, but we use arbitration as a main mechanism to to study about arbitration, and also we have the VF Center. Recently, they have many people working on that, and also the secretary of that center also come from our school, and that's also my student. And now she occupy the secretary of the VF Center, and many people serving arbitrator. That's why we feel very excited to invest in this matter of arbitration. So in general, we study about arbitration, and also I think you have very good understanding about arbitration, negotiation, mediation, because that's not really a complicated subject. That's very easy mechanism. The way is we need to understand what is the nature and the character of every model. So in the future, we choose our best model in order to participate. So mainly we focus arbitration again. So the arbitration, we have seen about the history, the characteristic, the role, comparison, and because they need some private sector beside the court system, because recently the court system overload, and the freedom of the party, they want to find some private, more effective, faster, in order to save time for the business. So that's why the idea recently have been very developed at the moment. Okay. So at the character about the theory, you already know about that, about a legal institution, private, voluntary, confidential, and then a legally binding result for some of model. About the arbitration. So about arbitration, I design as the presentation of every proof. We mainly focus some character. For example, the very important thing is about arbitration agreement. Because the first condition, we need to have an arbitration agreement in order to bring the dispute in front of the ADR body. The second character I want you to know, that's the independent of arbitration agreement. So instead of the contract may be valid or invalid, the arbitration clause will be independent. So the main purpose that they want to define the jurisdiction for the arbitration center. And next, multiple dispute into the same case. That means they want to regroup the same dispute to resolve one case in order to save time. And the next one is about the relation between the court and the arbitration. That means sometimes they can apply the temporary emergency measure in order to resolve the case. And the next one is about the competence of board of arbitration. Okay. So that is everything about the program. And some things you want you to remember is about the model. So about the model, we have institutional arbitration. We were very permanent, and then we have ad hoc arbitration. Some other character, as I think you will be acknowledge this knowledge already. So about the step, the process, we have submission, hearing, and award. Okay, the final award of arbitrator. And here, some other matter is about applicable law and dispute settlement method. So if in the future you have time, you can invest more on this matter. So this matter is much more complicated. So that's in the model of the duration to resolve the case. Okay. So to start arbitrate to lawsuit, less than 25 days, and then to constitute an arbitral tribunal is, more than 1 month, because it's not easy to find arbitrator. So I think the most difficult thing in this model is to find a suitable arbitrator. If you don't find a suitable arbitrator, I think your case will not go too far. So that's why we need to choose very experienced and famous arbitrator in order to resolve the case. So that's why they make the constitution of arbitrator tribunal. They consume the time, a lot of time to do that. And then the secretary of the arbitration center, normally they will arrange this matter. Okay, about the model, I think if you participate in the moot court competition, or you can see the model that we have the rules, the procedural model for the claimant and defendant, the claimant and respondent winning case. Okay, so I recommend that if you want to practice more on this issue, you can go to the VX Center to participate in some hearing, and then you will understand very clearly about the case. It's many our students are now working on VX Center. So you just go to the center and say you want to participate to some hearing, and then they will let you in. Okay, about procedures, concept, formulation. So besides that, we also have many international arbitration centers in London, in Hong Kong, in America, in some other country, many. And Singapore, the most nearest center. So that's all about, that's everything about the subject. And for the test, independent test on Wednesday, so you can revise the independent of arbitration agreement. So the group 4 can share the slide and your writing to the yellow group, so the people can revise this matter. So I will give you 2 questions for that individual test. Okay, so that's everything about the subject, the idea. And I think the subject's not really top thing. It's just about the technical things, how to resolve the case, characters and the things. And the main purpose of this subject is for you to understand that beside the official dispute resolution by the court system, we also have some private entity to resolve dispute. So that's why we facilitate that model. So in the future, you can use that model according to your demand. All right. So, do you have any other question? Rồi, xin chào các em còn câu hỏi gì nữa không ạ?
Em thấy ổn.
Nam hỏi gì không Nam?
Dạ không được.
Ok. Nếu không hỏi gì nữa thì chúng ta sẽ tạm biệt ở đây nhé. Và hẹn gặp lại lúc 2:30, 2:40 gì Nam?
2:30 rồi.
2:30 nhé. Ok. Okay, thank you very much for your all, and see you at 2:30. All right. Chào tạm biệt nha.
Dạ vâng, dạ vâng.
Dạ vâng.